it, and we'll get started. It's about 1 after 12, and we've had people join us. I think a few others as we will join us as we move along, but we'll go ahead and get started. We appreciate your time today, and we'd really love for this to be as interactive as it can be as a webinar. So if you have questions as we're moving along, please type them in down here on the bottom right, and we'll try to answer them as we move along, and if not, at the end. So let's get started. First off, we've developed this new approach to patenting, and when we say patenting, we mean filing as well as prosecution and pruning. After talking to our clients who seem to be living in this perfect storm of demands, from CFOs wanting to know why patenting budgets are so high and what are we getting out of it, to increasing globalization activities and pressures around what do we need to do where, and what about China, and what about Japan, and also looking at IP budgets as being a place where they can always cut, where the CFO or the accounting group wants to cut because those assets are viewed as oftentimes, if you're not in pharma, as an extraneous asset and maybe a cost center as opposed to something that can build value. Additionally, in the industry, there's an overwhelming amount of data available now, from scrubs of the PTO websites to how to analyze different forward and reverse citations of your patents to see what to keep, what to not keep, and they're all being offered by all these various vendors. And so it just becomes overwhelming. And at the end, you've been asked to do more with less. And that is just hard. And so what we are trying to offer here is some hope that there is a way to do that, that you can do more with less if you do it strategically and with a thought to aligning your patenting decisions with your business strategy. So you can control costs, and you can continue to build valuable, high-quality patents that can hopefully be worked with your business in terms of leverage and being able to create assets that work for you as opposed to just that exist. And our solution, we believe, helps you create more efficiently procured, robust patents that you can, in fact, leverage. So moving into how to start thinking about patent decisions differently, let's kind of look at these two illustrations. The first on the left is and I'm just saying your generally, meaning an in-house counsel. But on the left here is your budget, if you think about it, and the different pieces. And they may very well not be equally apportioned. One piece here on the right is application prep costs, the preparation. And oftentimes this is sent out. It can be done in-house by hiring more people or something like that. And oftentimes this quarter of the budget, or this piece of the budget, is the piece that in-house counsel pays the most attention to. But what you'll come to see is oftentimes that is the most ineffective way to control your budgets. The other is staffing and systems. And then the two biggest pieces, oftentimes this can be anywhere from 50 to 75% of your overall patent spend. These are the two that we feel if you can focus on and optimize, you can decrease this overall circle. These two pieces are your patent office official fees. That means the official fees that you incur when you file, from a PCT application into the nationalization stages, for instance, or through the Paris Convention. All of that involves patent office fees. Additionally, as you know, to keep patent applications pending, you have to pay annuity fees and renewal fees. And then to keep patents in force, you need to pay maintenance fees. That all comes into this. And we've had clients where 60 to 75% of their budget is this official fee piece. The second large piece is foreign prosecution if you have a portfolio that involves foreign prosecution, because outside counsel in other jurisdictions, we continue to hear, is much more an unpredictable cost because it's harder to control. I've heard hundreds of instances where there is an outside counsel that will send something in a foreign language. The in-house counsel says, wait, I can't even understand this. Please send me a translation. And then finally a translation goes, but no recommendation. So then you go back and you ask for a recommendation. And there's probably a 6 or 7 email exchange to get actually the useful information. And for each one of those, the in-house counsel is being billed. So this is a piece that has a lot of variability, and people feel like they can't control it as much. So this is kind of your overall pie. And the solutions we're looking at focus really on these two and how to make them work better for you. Because by doing that, you can eliminate the sources of waste. And the sources of waste in this budget are when you seek patents that won't facilitate your business goals, so they're not aligned. If there's unnecessary and uninformed prosecution, it increases this piece here, the prosecution costs from counsel and vendors. And what we mean by that is, for example, where you're trying to get broad claim coverage and therefore incurring 2 to 5 office actions in a case, and that claim coverage in that jurisdiction is actually irrelevant because enforcement is not available or the activities of the business don't justify broad claim coverage there. That would be an unnecessary prosecution and an unnecessary cost. What we mean by uninformed prosecution is oftentimes during a prosecution life of a patent, you will get an early indicator of viability of those claims. For example, if it's a PCT case, you get an ISRWO search report, and that can give you some inclination as to what the viability of your claims are. If that is ignored, or not implemented in the next set of decisions. So for example, let's say there's a good search report that says the picture claim that you put in is allowable but nothing else is, the informed way to prosecute would then be to take that picture claim into the jurisdictions where you don't need to incur the prosecution costs, and that becomes an informed prosecution and you can control costs. So that's a big source of waste if those two things aren't being managed. Another is maintaining assets, so therefore this is inflated, that no longer match the business goals. It could be because the business goals have since changed since those assets were filed, or these assets were acquired during an acquisition and they no longer match the activities. I mean, there's many reasons they can be irrelevant, but continuing to pay those because of, and the last one is risk aversion, because a lot of times people in-house don't want to be the one who killed the patent, especially business managers. They continue to maintain these irrelevant assets. And the reality is these two pieces become large hamstrings on your overall budget and what you can shift to protecting and acquiring new assets around ongoing innovations. So that's this slide was really to give you a sense of kind of where we're sitting and where we think you sit. So how can you reduce those sources of waste that we just talked about here? How can you reduce this? Well, basically, you do it by objectively aligning your business strategies and your patenting strategies. So what do? You take into account your business actualities, and what this stands for is make, use, sell, and where I am strategically is the ST. So for example, I'm looking at places in the world that I have a strategic reason to be. So for example, I get a tax incentive, or I get preferential contracting rights. Mexico is an excellent example of that. If you're not aware, Mexico has a regulation that allows a Mexican government or a Mexican entity to forego an RFP process if the applicant is a patent holder. And there's not a lot of scrutiny around with the claims coverage, but the patent holding status conveys under the statute an exclusivity, and therefore the RFP process can be skipped. So you get what we call a contracting preferential treatment. So that's another strategic reason to be there. So when you're looking at business actualities, look at what am I doing where? Where am I making? Where am I using? Where do I sell? Where are my top revenue jurisdictions? What do I need to protect? And then what jurisdictions do I need a strategic advantage in that patenting gives me? That's your business actuality box. Your second box you need to consider is what are my competitors doing and how much do I care? The first part of how much do I care gives a sense of which is more important. If I'm blocking competitors, if I'm wanting to maintain some power over competitors, then this piece may have more weight in my considerations than my business actualities piece. but oftentimes they're equal. Or sometimes the business actualities and what the business is doing in protecting those revenue sources and creating opportunities for the business is actually more important, and therefore the weight would not be equal. At any rate, in competitive intelligence, you want to understand where your chief competitors are making, of course, using, selling. So what are their top revenue jurisdictions? Where are their sales offices? Where are most of the sales offices? And then also you want to understand where are they patenting? Because in that patenting, there may be jurisdictions that they think, a competitor thinks is important that you haven't picked up yet here. And it gives you a sense to figure out why is that? Is it possible that they're going to operate a new venture there? Or they're seeking to partner with a local partner? Something like that. So you need to look at also what are they doing patenting and where, and then see if that educates something you need to do here. Because that may tell you what strategic advantages they're getting in some jurisdictions that you didn't consider and we don't have privy to without confidential information. So that's the competitive intelligence piece. The third piece that you need to look at in this consideration as you're aligning your strategies with your business is the jurisdictional realities. And this is oftentimes the harder piece to get your hands around, because what this is looking at each jurisdiction in its individuality and looking at it relative to all of the other jurisdictions to determine how valuable a patent is in that jurisdiction. And that value is educated by lots of different inquiries, including what is the court system in that country? Is a patent owner able to assert a patent? Even if the patent owner is able to assert a patent, how much of a bond is required? Is it 10% of the perceived judgment, like it can be in Brazil and China? How corrupt is the government? How stable is the government? How robust are the IP protections? Can a non-resident company without a local partner sue? Those kinds of questions that oftentimes in our daily practice we don't have a lot of time to keep in touch with, but those are the real key network questions that educate what jurisdictions will ultimately make sense. So there's this jurisdictional reality database. In our tool, we've been able to put that in a database and maintain it. There are sources that you can obtain this information if you were doing it on your own. Different comparative rights index, things like that will help you. Oftentimes, if you're going to local counsel, however, you get a biased view. So it's important to look at objective sources as well as subjective. And combining these three, you can ultimately develop your strategy. Because this can be time-consuming, we came up with what's called this Patently Integrated Strategic Patenting Advisor. And like I said, you can do this manually, but this is really how you get to the strategy. But we came up with a way that makes it slightly easier, and what is called our Strategic Patenting Advisor. And what we do is we work with the client to ascertain these business actualities and goals, looking at today, tomorrow, 3 years from now, 5 years from now, however far they can look out. We look at competitive intelligence, do the research, and then we look at the jurisdictional realities and do that research. And then by combining these three, we integrate them into a single number. And we're calling that the PI Strategic Index. And what that means is it's Patently Integrated Strategic Index. And depending on the value, let me go back up here. Depending on the value of this and why they're seeking IP or patents, and this and why they're seeking patents tells us the importance of all of these answers. And these are just examples. These are not all of the inquiries. But the inquiries that are relevant to the client are taken into account, and they're weighted according to the client. And through that algorithm, we're able to come up with this index number, which is a single index. The idea is that this single index number creates, one, a single unique way to communicate the degree of alignment with maintaining patents and filing patents in those jurisdictions. So for instance, here in the green, we've shaded it just to make it easier. The number right now, a top number is 273, it just is. And we've done an artificial cutoff here at 200. Anything above 200 is judged to be most aligned with your business decisions. So that would tell this client Brazil, Germany, and the U.S. are most aligned with your business goals. And if you look across the answers, let's look at Germany, for instance. Maybe the client is selling there. They're definitely making there. They have manufacturing centers. They would definitely enforce because Germany has a robust system, and we have a tax advantage potentially for being there. Our competitors are there, and they're making and using and selling. Therefore, this is a strategic jurisdiction and where we want to be. We not only want to file there, we want to maintain assets there, and to the extent we're prosecuting cases in Germany, we want those claims to be fairly broad. Therefore, we probably want local counsel to have a little more control of that prosecution. Working down the list, these yellow numbers, which break at 200 to 150 in this chart, this shows that there is some alignment, but not as much as the green. And in this yellow to orange region, these are indications that more due diligence needs to be asked as to why assets are being maintained there and why they're being filed. So for instance, let's go here. In the Netherlands, the client is maybe using and selling, maybe they're not making, and they wouldn't enforce there. Yeah, maybe there's a reason to be there. Competitors are selling there, and they're making there. So what we would need to look at is what is the claim scope relative to what the competitors are doing and our goals with respect to the competitor in the Netherlands. If this is a jurisdiction that we would want to keep our competitor out of because it's somehow important to us for some reason, then we want to file. If it's not, this is one where we may be able to have some cost savings and skip that jurisdiction and holdings. But you have to look at the actual business reasons behind it. The orange, this indicates that it's even less aligned than the yellow. So again, this just begs more due diligence as to filing and maintaining those decisions. So for example, here in Algeria, the client is, it's DZ is Algeria. The client is definitely using and selling, but they're not making. They may be enforcing, probably not, because there's really no system there. And the competitors are using and selling, but they're not making. So here, let's say I have a manufacturing claim, a method of making claim. I wouldn't really be able to enforce that against anybody because nobody's there. So maybe that's not a claim I need to file. So this gives you some ways to look at the jurisdictions relative to the inventions themselves and where they fit within your business model in order to decide what to do where. These red jurisdictions are ones that are the least aligned with your business and represent opportunities for cost savings. And generally, they become less aligned and lower in the strategic index because the degree of activity in those jurisdictions is not justified as relative to the others. And again, this is all relative to each other. And the intent with the strategic index is to create a common vocabulary that allows the IP department to speak to the CFO, to speak to the business, and you can all sit around the table talking IP strategy in a shorthand that everybody understands. The way I kind of think about it is when you buy a car and you have FICO scores, and people understand that credit score very quickly. This is kind of the same thing. It gives you a strategic score as to where you need to be. The score then can be used when the business and legal are meeting to decide how to prune. So for example, if there are red assets and they're shown as really not aligning here, those are likely maintenance fees and annuity fees that we might be able to skip. This gives you a triage into how you look at it, for instance. And in the orange, these might be ones that we can keep, but maybe not. We need to look at what they're doing relative to our activities. Same with yellow. And then the green, these are likely ones that are strategic and probably don't require much time in considering whether to prune them. So it gives you a way to asset triage, and that's really helpful when you're dealing with large portfolios and don't have a whole lot of time. So for example, you could walk into a pruning meeting with this kind of analysis and this kind of diagram that would then list the patents that show up in each section and go from there. So it would really cut down on time, making that meeting much more meaningful. It also helps in creating intelligent and informed prosecution approaches. So let me show you what I mean by this. In the gray on the left, this is probably how we all learned to prosecute patents. You start with broad claims, you file those all over the world, you allow them to spin, for lack of a better word, in each jurisdiction until you get to the ultimate claim scope towards the bottom in each country. And what that really results in is dollars upon dollars upon dollars. And when you put into the case that most patents, or not most, but a lot have extra pages and extra claim fees and big translation fees and all of that, this dollar sign it's very large. And so what this approach that we're promulgating is, instead of looking at it as a reverse triangle, looking at it as a triangle in which you seek claim scope that matches your activities. So for instance, going back to the main chart here, these orange, red, let's just assume you're not going to prosecute in because we've assumed that they don't align with the business. We're going to skip them. We're going to use that for cost savings. In the orange, yellow, and green, moving forward, in the orange jurisdictions, I'm probably not going to enforce there. It probably doesn't matter a whole lot how broad my claims are. So what I'm going to do is when I file my case, I'm going to include an embodiment, probably in a claim that's almost a picture claim, but not quite, but at least something, some version of a commercial embodiment. And if that looks allowable, that's what I'm going to file. And the reason I'm going to do that is because the spin doesn't matter, because I'm going to get the claims that I need in that jurisdiction. And in that way, I can save money. Every office action I can skip in each country is $3,000 to $5,000 on average. So if I can skip office actions in my orange jurisdictions, let's just use this example. I have 3 orange jurisdictions. Let's say I file in all 3 of those jurisdictions in this family, and I save 1 office action at $4,000 apiece. That's the average of 3 to 5. I'm $12,000 saved just by filing a narrower claim to start out, and just if I eliminate 1 office action. So this educates a prosecution strategy. In the yellow, you want to seek a claims strategy that is consistent with the activities there. But again, you don't want it to spin unless it needs to. So in jurisdictions where the jurisdictional realities show that you can achieve your objectives in that jurisdiction, broader claims may be important. Where the jurisdictional realities are such that you really can't, then I'm going to want to file more narrow claims. In the green, this is an opportunity to where I probably want broader claims because these are very important jurisdictions. And in that case, I may want local counsel. Let's go back to the green. I may want local counsel in U.S., Germany, and Brazil to help control the scope of those claims and the wording of those claims. And the reason being is that those are my most strategic. Those are most aligned with my business goals. I probably want those claims as broad as I can get them, and I want them to be valid under that local law. So in essence, what this ranking does is it gives you a way to strategically manage the prosecution of your global portfolio. So you don't have to necessarily have one coordinating counsel for every single case. You have coordinating counsel that manages the content of jurisdictions in the orange, jurisdictions in the yellow, but the green, there's a little more local control. So you have a hub and a spoke that works according to the strategic alignment of the jurisdictions. So that tells you how to strategically manage the portfolio as you prosecute. The other thing that this does, let me go back, is by looking at these jurisdictions and deciding where you're going to file. If you walk away with anything today, the one thing I'd like you to walk away with is that one size doesn't always fit all in terms of the best filing strategy. What you have to do is determine what is the best strategic filing route once you've decided on your jurisdictions, because that can be a tremendous cost savings in what you're doing as opposed to just knee-jerk filing things exactly the same way every time. And let me show you what I mean. I have some real examples. So in this example, this was an example I took to a corporation to show what I meant. And I think I've genericized it enough to where you can't tell who it was, but the example still makes sense. So in this case, there was a U.S. application, and then it went to a PCT 12 months later, and then 18 months later was filed Japan, China, Canada, and EP. during the PCT, there was a partially favorable ISRWO, which is important because that's what we call an early indicator. Down below, and I probably won't walk through these, but this is how we came up with the money we think that was spent in this portfolio, or this family. And it's based on flat fees. They're consistent with throughout the examples I'll show you. We assume an office action here is $3,000. And we also, the official fees, when they're actual, we've noted that. And the other fees are based on assumptions, but they're consistent throughout the examples I've given you. And so this is how the filing a family existed. Let me, at the top, we think the total cost for this family at a minimum were $48,700. And when I talked to this company, it was actually quite higher, a lot higher than that. And I don't know exactly how much higher, they wouldn't tell me, but I do know it's a lot higher than that. So I think my numbers are consistently conservative. So then, if you do it in an informed way, and still file the same way and get the exact same results, let me show you how you can do it with 23 and 25% savings. So if you still file the U.S. and do 12 months into the PCT, you can take that partially favorable ISRWO, do PPH back into the U.S. to speed up those claims before you ever get to the foreign filings. And you can do an Article 19 amendment in addition to any amendments that you've gotten out of the U.S. prosecution education, because hopefully through the PPH you've gotten at least one office action or two, and then file those more narrow claims here. We assume then that those more narrow claims eliminate at least an office action, and some office action. And doing that, even with the additional Article 19 amendment and the preliminary amendment with the PPH in the U.S., you're at 23% savings, like operating it in an educated way. If they had chosen to use CIPO instead of the EP as a search authority, it's a 25% savings. So how you file and then what you do with the information you get along the family timeline can make a huge difference in your cost. Because if you extrapolate this over 50% of your portfolio, let's say, it's a massive amount of savings. Let me show you another example, just to show that this is an entirely different company. This application, this family started in India. We assume there was a local Indian inventor working in a research center there. Then it went to PCT, and then following that, 18 months, there was a Russia, Canadian, U.S., and an EP case filed. This 12-month waiting period and then the 18-month to foreign was pretty standard for this client. Here, again, we've put down the flat fees that we assume applied. If there's actual fees, we've noted that. If there's assumptions, we've noted that. And I should note that none of these examples include translations because that would just be too hard. At any rate, for this family, we've estimated about $36,800 has been spent on this family. I have heard I heard from the client that is actually low as well. So moving forward, taking this into an educated approach, what if you went India into PCT, got the partially favorable ISRWO, which is exactly what happened, PPH that into the U.S. and amended those claims, and then took that education and made these decisions. And what we found out, because what happened here, if you'll notice, the Russia, the Canadian, and EP, the Russian we couldn't figure out the status, but the Canadian and EP are abandoned. And what the client actually told us in the meeting was that they figured out that filings in those jurisdictions with this technology were not strategic. Basically, the claims weren't important to them, so they abandoned them. But they still paid all the filing fees. So what we're saying is, well, if you had done the strategic analysis, you could have just skipped those official fees, let those go, and you're at a 32% savings. So if you look, again, if you think about these filings, strategically much more on the front end, use information to educate decisions along the way, you don't run into this problem where you have paid all of this money, official fees for the Canadian and EP 5,000. You can skip this, and it can add a lot of money, subtract a lot of money from your waste in your budget. So basically, business actualities plus competitive intelligence in this jurisdictional reality database, background, you can come up with how to strategically align your patenting decisions. If you also look at, what is your overall driver? Are you trying to do the lowest cost? Do you need to delay decisions because the technology is developing? You can get to what you think is a filing route by looking at where you're going to get those early indicators and then what's the cheapest way to go. So for example, this early indicator, actually taking it and do something with it before you have to make a next decision. That's what that means. It can greatly improve your patenting decisions. That savings can then be used to draft higher quality applications, more applications around key technologies so that you could, for instance, survive a PTAB attack. If you have one patent on one key technology and it's challenged at the PTAB and potentially knocked out, you're kind of hosed. If you have a picket fence around that technology of patents, you can rely on others. So this gives you more money to create defensive strategies. It can also be used to encourage innovation within the company, for example, through inventor awards or other kinds of innovation stimulations. And you could potentially buy updated technology systems that can help track innovation management, things like that. So that's how your savings can be used. Let me show you a case study. This is a company that we did this analysis with. It's a large multinational product line for a Fortune 100 company, an energy company. And this is a very large product line for them. We looked at their manufacturing locations, their revenue sources, where their inventors are to design these filing routes. And we looked at 4 primary competitors that they identified. And again, looked at their manufacturing, where they're using, where they're making, where they're selling, and what they're patenting. And came up with some analysis for them. Traditionally, this company filed in 34 jurisdictions. Just let that sit for a second. That's just a huge amount of jurisdictions. It's pretty unbelievable. And each family was filed in an average of 20 jurisdictions, which is a huge amount of jurisdictions, as you recognize. So let's assume that each of those jurisdictions has an official fee when filing of an average of about $3,000. Let's just use that as a round number. It's easy. Times 20. So that's $60,000 just in official fees and filing costs per family. That doesn't get into prosecution costs, outside counsel costs, translations, anything like that. I mean, this is just official fees. It's $60,000. They filed at least 50 new families, sometimes up to 100. Let's stick with 50. They have 50 new families filed each year. That is $3 million in filing costs alone. So we came in and we did this analysis and we said, all right, let's think about this strategically. Let's look at your activities, let's look at your competitors, and let's decide what your strategic jurisdictions are, and let's move forward. So this is a genericized chart from this analysis, and we were able to say, look, I know you're filing in 20 and you prefer to file in 34, but 5 are really strategic, and let us tell you why. 1, these are 3 of them are your top revenue. 2, you've got a manufacturing location and you're doing some R&D in these jurisdictions. Your competitors are heavily selling in this jurisdiction, they're manufacturing in this jurisdiction, and they're patenting in this jurisdiction. These are the 5 you want to hit every single time. These are assets you want to maintain, as well as assets in which you want to get broad claims. So these are where you incur the spin, for lack of a better word. These others, there's 11 in the orange, in the yellow. In the yellow, these are less strategic. And what they were really surprised about is Italy, because Italy is where they thought was their most important jurisdiction for various reasons. And it clearly was not. And once we were able to say, look, you said blocking competitors was key. Your competitors are not in Italy. Yeah, you are, but they're not. And so if that's one of your primary goals, then Italy doesn't make a lot of sense and is not nearly as strategic. Now, does that mean they can't file in Italy? No, not at all. It just means that, if you're trying to prioritize dollars, this is one way to look at it and think that maybe Italy isn't your top priority. And this tells you why. Another that was interesting for them was Australia. They thought Australia was very, very strategic, and because it is a revenue source for them, but there's nothing else really going on there. Competitors somewhat sell there, but very small. And so they were very surprised to see that. And the recommendation really was, okay, here's your top ones you want to hit every single time. When oil prices are low and budgets are cramped, you still want to hit those. But when the yellows, if you have a little more money, prioritize these, but you don't have to hit them every single time. Make sure the claim scope matches your goals and what you're trying to achieve. By doing this, we were able to show that if they only filed in the Tier 1 5 key jurisdictions using the same math at $3,000 per jurisdiction in just official fees, then that was $15,000 with 50 new families. That's $750,000. That's a 75% savings in their official fees. So if you go back in your head to the circle of the budget slide I mentioned before, that is a huge reduction in that piece of the budget, leaving you, more dollars to spend on quality applications, et cetera. If they filed in 10 discretionary jurisdictions, let's say, 10 total, they're still at a 50% savings. And they can justify that to the business. The recommendation was also to prune based on this alignment. Look at the green jurisdictions and note that those are strategic and maybe not let's spend a lot of time, let's just pay those maintenance fees. On the yellow, orange, and red, those are things we likely want to prune and then decide how much time to spend on them and to determine that. And then we were able to develop a hub and spoke prosecution management recommended form for them, recommending where broad claims made sense and where it didn't. So looking back to their chart, these are jurisdictions in which they want to get broad claims. These are jurisdictions where local counsel is going to be important. Want to have quality local counsel doing good work to make sure that those claims get as broad a scope as you can get and that they're enforceable in that jurisdiction if necessary. And then these can be more of a spoke from a hub, depending on how important a particular claim scope is in that jurisdiction. So you can save costs by dictating more of a claim scope and an approach in these jurisdictions. Let's talk about the strategic filing routes. Again, once you've picked the countries where to go, so this was based on the Tier 1 countries in this analysis. And the inventor profiles they gave us were to assume an Italian resident, an Indian resident, but the research was performed in the U.S. Based on that, the strategic filing route we determined, and they wanted the lowest total cost. We always want to be filing in the lowest total cost way. All right. Generally speaking, the lowest total cost is never going to include the PCT. Something to think about. So here, you need a U.S. and/or an Indian foreign filing license to hit the Italy prosecution, because Italy is one of those jurisdictions that requires a first filing as well as India. We prefer Italy over India in this situation. Go Italy. You get an EPO search in 6 to 9 months. By the way, the Italy filing fee is around $300. The only negative is you have to have an Italian translation, but you get an EPO search in 6 to 9 months. And from that, you can take the claims that you think are going to be allowable into the yellow jurisdictions or the green jurisdictions moving forward. Since these are green, you're going to want to try to get broad claims here, here, and here, and then validate those in the EPO jurisdictions. So we're about at 12:40, and I haven't seen any questions come through, so feel free to add those in. And the conclusion really here is we want to align your patenting. The best way to use your budget dollars, eliminate waste, and still achieve a high-quality global patent portfolio is to align your patenting strategies with your business goals using data, and that will really help you control costs and eliminate this waste. You can educate all of your patenting decisions from this point in terms of what you prune, what you keep, how you file, how you prosecute, and how you manage that. And all of that will give you a much higher quality patent portfolio. And with that, I want to thank you all for joining us and would love to hear any questions. You're happy to type them in or ask.
For joining us today. Should you have any questions after our call, please feel free to reach out to Carey Jordan or Donna Haynes. This concludes our program. Thank you.